Today we're talking with Judge Ila Sensenich. Judge, would you state your date and place of birth?
I was born on March 6, 1939 in Pittsburgh, Pennsylvania.
And give us some idea of your background on your parents.
My father was a lawyer in Greensburg, and my mother was a housewife. They both played a major role in my life, in my decision to go into law. I was an art student at Westminster College when I wasn't a very good art student. I didn't think I'd be able to make a living as an artist, so I was trying to decide what I wanted to do in my life. And I should say, my mother had always emphasized the importance. She felt it was important for women to get an education and to have a career. So I was trying to decide what to do, and I finally wrote a letter to my parents. This was my senior year of law school, college, I'm sorry. I was telling them I wanted to find something that would be, I didn't want a 9-to-5 job. I wanted something that would be challenging and interesting. I wanted something where I would be meeting all kinds of people, intelligent, well-educated people, and people who were not so intelligent and well-educated. I wanted something that would always require me to be learning new things, and I wanted something that would be a service to others. When my father came to pick me up for Christmas vacation, he said, "Your mother and I were interested in your letter. You want to be a lawyer?" I said, "I don't want to be a lawyer." "Daddy, what do lawyers do?" I said, "Do they have to memorize the law?" He said, "No, they don't memorize the law. They learn to research it and look it up." Oh, I decided to go to law school. So then after I graduated from law school, I practiced in my father's office. I had a small, my office started out in the library of my father's law firm. And I would be given the minor cases of the lawyers in the office. It was the office of Stewart, Belden, Sensenich, and Harrington. I did title searches, which were the bread and butter of young lawyers. I think some of the other judges who have been interviewed have talked about that too. It was very boring. You'd have to go through all the dusty records in the House of the Recorder of Deeds and Register of Wills to do the title search. And you didn't get paid a lot of money, but you got paid promptly, and it helped to pay office expenses. And then another thing that I did with my father, his hearing was going bad. And when he would have personal injury cases and other cases which were going to court, if he couldn't get them settled in an early stage, he would turn them over to me to investigate and to prepare for trial. I loved doing that. It was fascinating to go to the scene of the accident, interview the witnesses, take photographs or hire a photographer, and then I would actually try the case. My father would be sitting beside me in the courtroom, but he couldn't hear what was going on, so he wasn't a lot of help. So he played a major role. And my mother, of course, was very supportive all along of my education and career.
Just to go back, you grew up in Greensburg, is that correct?
Yes. Well, I grew up in Irwin, Pennsylvania, and I practiced law in Greensburg.
And you attended, you mentioned Westminster College, and you studied art and philosophy. Do you think that had any bearing later on your legal work?
Well, it's interesting that you mentioned that I was an art student, and when I was in school, I was never very interested in what was going on until I took a course in philosophy in college, and I just became fascinated by it. I found myself going into the stacks of the library to read more by the philosophers. The next time I've had that enthusiasm for education was when I was in law school, and I found it absolutely fascinating. In that rather than in law school, rather than listening to lectures, which I didn't do very well. You would be assigned to read certain cases, and then you would be called on in class to stand up and tell the class what the case was all about and what the judge held. The professor would then interrogate you and then would ask hypothetical questions. Well, if the facts were different, what do you think the court would have decided, and do you agree with that decision? So I found this really fascinating. And I should add, when I started law school, there were 4 women in my class. We were broken up into 4 different sections. They assigned 1 woman to each section. So each of us was in class during our first year of law school with all men. And every time I'd be called on in class, I felt that my classmates were waiting to see what this woman is going to say. So that put additional pressure on me. Maybe I should add another experience I had when I started in law school. I would walk into a classroom and I would sit in the front row center because that was the best place for me to really pay attention. And no one would sit to my right, no one would sit to my left, no one would sit behind me. I sort of felt like I had leprosy. And later on, as I got to know my classmates, I found out that they had been intimidated by a woman in their class. They thought a woman had to be really bright and really intimidating to go to law school. They found out that the 4 of us, the 4 women in the class, were very normal and human, and we got over that. In later years, we didn't have to sit all alone in class.
This was Dickinson Law School.
That was Dickinson Law School, yes.
How do you think that experience shaped you, if it did at all, as a judge?
I guess I was used to working mostly with men, of course, and when I started practicing law in Westmoreland County, I was the first woman to get into litigation in Westmoreland County. I think there had been 2 before me. One was the daughter of a judge, and I heard that she had gone down to Washington, D.C. to practice. And another was a woman who spent most of her time raising dogs and children, and she also did title searches and some office work, but she didn't get into court.
You began practicing in 1964.
That's right. I started practicing law in 1964, and there were 8 of us who were admitted to practice law. Of course, the others were all men. And this was a year after the Supreme Court had decided an important case holding that every criminal defendant who was facing the possibility of trial in the state courts had the right to be represented by counsel. I think it was Gideon versus Wainwright. So all of a sudden, all the judges needed to get attorneys for the indigent defendants in their court. This was before the days of public defenders, although the Allegheny County Bar Association did have a public defender. There was no public defender in federal court until many years later, and there was no public defender in Westmoreland County where I was practicing. So the judges would call on the newly appointed lawyers. I was admitted to practice law, and each of us was handed an order appointing us to represent a criminal defendant. That was on a Friday. I went home, spent the weekend at home, very nervously anticipating visiting my client in jail. When I was in law school, I found criminal law fascinating. But I never expected to actually practice it. So I finally got up my nerve Monday morning, and I went down to the jail to visit my client. And I looked a little young for my age, so I was wearing my hair on top of my head like a bun to make me look older. And the warden wouldn't let me in. I think he thought I was my client's girlfriend. So I had to go back to the office, get my father, and my father came down and said, she really is a lawyer. She was just admitted to practice law on Friday. So I got to see my client, and I have to say I was unimpressed by the conditions in the jail. I sat on one side of a wall with bars on it, and he sat on the other side. And there was quite a strong bad odor in the jail, which probably influenced my getting involved in the area of the law of prisoners' rights much later after I went on the court.
Did you see yourself as some kind of trailblazer, being a female attorney in Westmoreland County? Were you aware that you might be a role model?
I didn't see myself as a role model early on in my career. I have to say, in preparation for this interview, I prepared an outline of the things that I did in my career on the national level and on the local level in the Western District of Pennsylvania. If someone had shown me that when I was in high school and said, this is what your career is going to be, I would have said, no. No, that can't be me. I could not do those things. Back in high school, I would have said I couldn't be a lawyer. So it's incredible to me as I look back. All I can say is when I got into law school, I had a passion. And throughout my entire career, I have followed my passions. And it has been an incredible career for me. Did I see myself as a role model? Back in those days, there were so few women in the legal profession that there was, at the beginning, there was no one to look up to me. And then over the years, gradually, there were more and more women coming in. And I'll have to say, when I became a magistrate judge, I always, when a woman appeared before me, I expected her to be excellent. Because you had to be excellent to go to law school, to survive law school. And so after a while, I would see some women lawyers who were mediocre, and I'm afraid I was hard on them. They didn't live up to my expectations. And then finally, I talked to other people, and I thought, well, I guess men have the right to be mediocre, so I guess women have the right to be mediocre lawyers too. But I still always expected the best of women. And I really tried to work with my law clerks, most of whom were women. I had some male law clerks, but I tried to work with my women law clerks, and after they left me, I tried to help them move on in their careers.
You had some inspirational figures when you were starting out as an attorney, and one of them you mentioned to me was Orlando Prosperi. You want to talk about him?
Yes. Well, I mentioned that I started out practicing criminal law, not because I'd chosen to do it, but by appointment of the court. Well, of course, I didn't know what to do. I hadn't expected to become a criminal defense lawyer. But there was an incredible attorney in Westmoreland County, Orlando Prosperi, who was the mentor of all the young attorneys as we got assigned to handle criminal cases. We would go into his dark office. He had a dark office with one spotlight coming out of the ceiling right in front of him. And he had a very soft, intense voice. But yet he had a booming voice in the courtroom. He was an absolute, incredible criminal defense attorney. You don't often meet a person like this. He was so committed. He always had time to work with us, to help us, to give us encouragement. We could go into his office anytime and discuss the case we were working on and discuss strategy. And he loved to do it. He was a great teacher. And then I told him one time I would love to work on a case with him. So he was appointed to represent a woman who was charged with murdering her husband, stabbing him with a kitchen knife when he was asleep in bed. It became known as the chicken soup case. And Orlando suggested to the judge that I be appointed to assist him in this case. It was a fascinating case. We realized that we could easily get her off by pleading insanity defense because she had a lot of emotional problems, and she was on diet pills. She had psychiatric problems, and yet she was on 4 times the dose a normal person should get. But that would mean she would go into a mental hospital. Orlando would not accept that. It had to be a not guilty plea, even though this woman had stabbed her husband with a kitchen knife when he was lying in bed. Well, the jury came in late one night with a verdict of not guilty. After that, a group of us went down to the closest bar. The district attorney, the assistant district attorneys, Orlando, the county detectives, and myself. After we had had a couple drinks, one of the detectives said to Orlando, "Orlando, what was your defense?" Then he added, "All I know is when my wife gives me chicken soup, I'm going to eat it." And the reason for that is Orlando didn't rely on a specific defense. He just portrayed this woman in such a pathetic way the jurors didn't want to find her guilty of murder. After I left Greensburg in 1971 to take the magistrate position, Orlando went to Rome, where he became a priest and an expert on canon law. Then at some time when he had serious heart problems, he came back to back to Greensburg. And he was seriously ill, but there was a murder case. The public defender, I believe, was handling it at that time. Orlando asked to help. He took over the defense of that case and had a brilliant defense. When that case was over, he was confined to bed for 6 years until he died. So he was just a tremendous inspiration for me and for all the other lawyers who were interested in learning criminal defense law.
You became Assistant Public Defender Dante Bertani in 1970. What was that experience like?
Well, I'll say that as I got into criminal defense work, I found it absolutely fascinating. And finally, the county decided to appoint a public defender. And they selected Dante Bertani, who was one of the young lawyers, who was a very active criminal defense lawyer. I decided I would like to apply for that position. But I knew I had a problem, because when I was in law school, I had run into him when I was working in my father's office in the summer, and he told me, "Get out of law, don't go to law school. Women lawyers are awful, they just create problems." So I applied. Actually, I sent in the application to be an assistant, and then I headed off for a ski vacation in Vermont. I came back and there was a message that Mr. Bertani wanted me to call him. So I called him, he asked me to come down to his office. When I went down, he said, "You know what I think of women lawyers?" I said, "Yes." He said, "Well, you're different, and I want you in my office. I need you." I think the reason was because I was known for preparing my cases very carefully and exhaustively. Dante was a courtroom lawyer. He didn't do much preparation, and he wasn't very well organized. And so I think that's why he felt he needed me in the office. So then I was a public defender, first assistant public defender for a year. And it was absolutely fascinating until I got a call from Judge Marsh, the chief judge in federal court. I got a call in my office, and he told me they would soon be appointing a new position in federal court, United States magistrate. These new officers were going to replace the former commissioners. It was going to be a full-time position, and the commissioners were part-time. And the idea was that the position would grow, and the magistrates would be able to take on more and more of the duties that the district judges were performing. So I applied for that position in 1970, and I think it took almost a year before the court got authorization to start this new system. Then on March 12th, 1971, Bernard Schaffler and I were appointed as the first two full-time magistrates for the Western District of Pennsylvania.
Tell me about some of your early experiences as a magistrate. In particular, there's a story about a difficult ATF agent that you encountered.
Well, I'll say the magistrate system was new. We were required to be attorneys. The commissioners had not been required to be attorneys. So it was a learning process. I remember one time an ATF, alcohol, tobacco, and firearms agent came into my office to apply for a arrest warrant or a search warrant. And I took a look at the papers and I said, well, I'm sorry, but you don't have probable cause and I can't issue this. Well, he was very upset. He said, I'll tell my supervisor. I said, fine. Since that didn't scare me, he said, well, I'll tell Mr. Thornburg. Mr. Thornburg was the United States Attorney who later was the governor of Pennsylvania. I said, that's a better idea. So he stormed out of my office. About an hour later, I got a phone call. He said, Magistrate, we've added some information to the affidavit. Could I bring it up? Would you take another look at it and see if you can issue a warrant? He did not realize that the magistrates made decisions whether to issue warrants, not the federal agencies, the ATF, the chief of the Alcohol, Tobacco, and Firearms Division, and not even the United States Attorney, that it had to be presented to a magistrate who was a judge, who made a decision and could refuse. And we did. I don't think they had ever had the commissioners refuse to issue a warrant, but we did.
Early on, what potential did you see for the position as a magistrate?
Well, it was very exciting to me that the Magistrates Act was very general when it provided that basically magistrates could do anything that was not in violation of the laws or Constitution of the United States. And the intent of Congress was that the judges would, all through the country, would experiment in the use of magistrates and find out what was most helpful to them. During my years on the court, my 35 years on the court, I was always working to expand the role of the magistrates to the extent that we were authorized by Congress, because the more the magistrates could do, the more it would help the district judges. And the more prestige the position had, the more it would attract really competent people to the position. And for me personally, it would make my job much more interesting and challenging. So during my whole time on the court, I was working both on the local level and on the national level to expand the jurisdiction of magistrates to the full extent authorized by law. And I'll say, after I retired, the Board of Judges approved what I call the consent proposal, which I had started working on 11 years before. This involved the maximum use of magistrates, where civil cases, when they're filed in federal court, are assigned either to a magistrate judge or a district judge. And I should say the title was changed in December of 1990 from magistrate to magistrate judge. And so the cases are now assigned to either a magistrate or a district judge. The parties have a certain period of time to consent to trial by the magistrate. And if they consent, the magistrate handles the entire case from beginning to trial and decision. I had first started working on that proposal in December of 1995. And The judges weren't ready for it at that time, but finally it was presented to the judges, and they did not approve it. In fact, I kept reworking the proposal to try to meet the objections that some of the judges had. Then after I retired, I guess the magistrate judges got together and presented it again to the Board of Judges, and they approved it, and it went into effect July 1st, 2007. So it's very exciting to me that when I started, we were working at the most basic level. In fact, my former colleague, Bernard Schaffler, Judge Schaffler, who was interviewed by this committee, when he was interviewed, he made the comment, and I'll say he was only with the court for about 8 or 9 months, that as we started, we were working as super law clerks to the judges. That was our role. And so he got out, and he went for more money. But I stayed, and it's very exciting to me that we went from super law clerks doing what law clerks do now to the judges, the magistrate judges on our court are now accepted as full judges. I understand that in about 75% of the cases, they get the parties' consent to have them be the trial judge. So, I feel I played a major role in that.
I know that was a long process for you, and one of the first steps in that was your writing a study called Magistrates Unlimited in 1973. What were the important findings in that, and how were they received at that time?
In 1973, Judge Aldisert, Ruggero J. Aldisert, a judge of the Court of Appeals, a dynamic person, asked me to address the Third Circuit Judicial Conference on the use of magistrates. The Third Circuit was composed of all the federal judges in Pennsylvania, New Jersey, Delaware, and the Virgin Islands. And the Judicial Conference met once a year. So his assigning me to address the Third Circuit on the use of magistrates was very exciting to me. As I said, the magistrate system was new. It had just gone in all over the country in 1971. And as I said, the Magistrates Act was very vague. So judges in each court in the country were experimenting in how to use their magistrates. So rather than preparing a speech, I did extensive research. I researched the history of the Magistrates Act, what Congress wanted the magistrates to do. And then I contacted a magistrate in every court in the country and asked them what they were doing. Were they working in civil cases? Were they working in criminal cases? How did cases get to them? Did they do one particular thing, or did they manage the case? How did the case get back to the judge? I got funds to do some traveling. I traveled to Washington, D.C., New York, New Jersey, Philadelphia, Buffalo, and some other areas, and met with the magistrates to find out what they were doing. And then I prepared a 300-page manuscript. It was mimeographed. My law clerks and my secretary and I prepared it in our office, handed it out to every person who attended the Third Circuit Judicial Conference. It was well received. In fact, that was the beginning of my getting involved in the federal judicial system on the national level. Little did I know that Roland Kirks, who was director of the administrative office, was present at the judicial conference. Well, I knew he was there, but I didn't realize what an important role he was going to play, because he went back to Washington, D.C., and it turned out Chief Justice Warren Burger was getting together a team, a small team, to go to London to study the English master system, because the magistrate system was patterned somewhat on the master system. And they wanted to find out more about what the masters were doing and how the master system could be adopted into our system. So Mr. Kirks told the Chief Justice, well, you have to invite Sensenich to be on this team because she knows more than any other magistrate in the country on what's happening right now in the country. Plus, she knows the legislative history. So I was selected as one of 3 magistrates in the summer of 1974, April 74, to go to London for a week to study the English judicial system. There were 3 magistrates, 2 district judges, 1 judge of the Court of Appeals, and Mr. Kirks. And we came back, we prepared a report, we met with the Chief Justice, and then our report was used by Congress as it was working on a new Magistrates Act, incorporating our recommendations.
Apart from these special projects that you did, what was your day-to-day work like as a magistrate in the 70s?
Well, there were 2 of us that started, and when Judge Safler left, Judge Mitchell was appointed to replace him. There were 2 of us, and early on we decided, Judge Safler and I decided, well, we had criminal duties and civil duties. We had the criminal duties that the commissioners had, where we were issuing search warrants and arrest warrants. And when someone would be arrested, they'd be brought before a magistrate to set bond, either release them on bond or commit them to jail, and then conduct a hearing to determine if there was enough evidence to hold them for court. And that could take a lot of time. Those were the things. We were on call 24 hours a day, 7 days a week. So we took turns. One of us would, every week, one of us would be on criminal duty, and we would handle everything that came up. So you'd walk into your office, maybe planning to work on a civil matter, and they would be hauling in prisoners, the people who were arrested, and we would have to set bond and drop what we were doing. We were also doing, as I said, we were super law clerks to the judges. When we started, we arrived at our offices, and the clerk's offices started hauling in foul after foul after foul. Social Security disability cases and habeas corpus cases. These are cases that we refer to as record review. The Social Security cases were cases filed by people who had applied for disability insurance benefits and been denied benefits. And then they were able to file appeal in court. Our job was to read the record, read the testimony, read all the medical reports, and make a decision whether the decision to deny this person benefits there was a proper basis for it. They were pretty boring cases to handle. They were important cases, and I took them very seriously, and I put a lot of time on them. But they were very routine. And then we also handled habeas corpus cases, which were cases by prisoners who had been convicted of criminal offenses in the state courts and were serving sentences, challenging their convictions on the basis that they violated the Constitution of the United States. So we would get these long records of long jury trials in the state courts, and we'd have to read the whole transcript and read the briefs of the attorneys. And the decision was this prisoner's, were his rights violated, his rights under the Constitution. And then in both of these types of cases, Social Security, disability, and habeas, we would write a long report and recommendation to the district judge, reciting the facts of the case and saying, I recommend that the decision denying disability benefits be affirmed, or reversed, or remanded for reconsideration. In the habeas corpus cases, we would recommend that the petition be denied, or that it be granted. Most of them were denied. I'd say 98% of them were denied. So it was looking for the needle in the haystack.
What was your relationship like with other members of the judicial system at that time, and were there particular people you worked well with or remember fondly from those days?
Yes, I particularly remember, again, let's see, Judge Aldisert, who was really a mentor in that, in addition to asking me to speak to the Third Circuit Judicial Conference, getting me that great trip to London, he was, a couple years later, he was chair of a committee of the Federal Judicial Center on how to handle prisoner civil rights cases. And in 1975, I had gone to the district judges and told them, we can do more for you. In that case, when motions were filed in prisoner civil rights cases, these are cases by prisoners who are serving prison sentence, challenging the conditions of their confinement, claiming that they're being denied medical attention, they're being denied a healthy diet, adequate diet, they're being denied fair disciplinary hearings. They can sue the prison officials for money damages and for injunctive relief. This was a new area that was developing in federal court. The courts were getting letters from the prisoners. These prisoners did not have lawyers, and they had plenty of time. So they were writing long letters complaining about the conditions of the prison. And the first reaction of the federal judiciary was to, on this first level, the district judges, was to dismiss them, at least most of them. And then they'd get reversed by the Court of Appeals. Supreme Court came down with some decisions saying prisoners have the right to be treated fairly and humanely. There were very hard cases for the judges to handle. The judges in federal court were used to having lawyers present their cases. And so they were becoming an increasing problem to the federal courts. So in 1975, I went to our judges and said, we can handle these cases. When you get the letters from the prisoners or the complaints from the prisoners, you can refer them, when they're filed, you can refer them to us, and we can do everything except basically dispose of the case. If we feel it should be dismissed, we make a recommendation, or if a defendant files a motion to dismiss, we can recommend that it not be dismissed. But we can do all the orders. We can take all that day-to-day work away from you. Well, one of the judges said, that's a good idea, but I think one of you should handle the prisoner cases, the civil rights cases, and the other should handle the habeas. So Judge Mitchell volunteered to take the habeas corpus cases, and I volunteered to take the prisoner civil rights cases. I have to add that there were twice as many prisoner civil rights cases coming in as there were habeas. And the habeas cases, the law was not changing much. It was pretty standard. Over the years, there were a couple changes that took place as far as what prisoners had to do to exhaust their remedies before they came into federal court. But the substantive law wasn't changing, where the law on prisoner civil rights was changing daily. And so I found that a really fascinating area to get into. And so I started following the law. Again, the prisoners didn't have any lawyers, so I was completely dependent on my own research. So I started keeping a notebook of all the cases as they came down. So my daily work was, again, there were only two of us. 1 week, I would be handling criminal duty, which meant 24 hours a day. I would get calls in the middle of the night when someone had been arrested. And in the early years, I would go to the courthouse in the middle of the night to have a hearing for this person. In fact, I'll never forget one night I went into my chambers and flipped on the lights, and the janitor who was sleeping on the sofa jumped up and ran out. And I ran into the courtroom and turned on the lights, and when I came back, he was gone. But when Bud Schaffler and I went down to, well, and I guess Judge Mitchell and Schaffler and I went to Washington, D.C. to seminars every year, we found out that we were the only magistrates in the country who were actually holding court in the middle of the night. So the judges finally decided we didn't have to do that. And we came up with a procedure where when a defendant was arrested, we would get information from the arresting officers, and if this person wasn't a risk of flight, we would authorize the prisoner to, the federal officials to allow the prisoner to sign an agreement to appear in court the next business day. And if not, we would authorize the marshals or the federal agents to incarcerate the person overnight. So that's what I would be doing 1 week. And then the next week, I would be working on the Social Security cases, Habeas Corpus, until I took over all the prisoner civil rights cases. And that was constantly reading these long, hard to decipher letters from prisoners to decide whether they had a valid case. Again, this was a case of looking for the needle in the haystack. Most of them were totally frivolous cases, but we couldn't say that without an analysis. And again, I kept an outline, keeping it up to date about all the decisions as they came down.
Why do you think the issue of prisoner rights was important to you personally?
I think maybe part of it went back to that first case that I handled right after I was appointed to represent a criminal defendant when I started practicing law, but also just my basic sense. I mean, back then the conditions in the prisons were really intolerable. Not much money was put into the prisons. They were at the bottom level as far as funding was concerned. And they didn't have, the prisoners didn't have anyone to go to. There were bread and water diets. Prisoners could be beaten. So I just myself, my basic philosophy, I felt the prisoners do have the right to be treated fairly. Doesn't mean they're entitled to gourmet meals or basketball courts or televisions, but they need to be treated humanely. And there weren't a lot of people who felt that way back in those days. I should say there was one attorney, Jerry Krakoff, who was a wonderful attorney handling prisoner civil rights cases. And he would take as many cases as he could possibly handle. And he was a leader, but he couldn't take all the cases. So I believed in prisoners' rights, and I also wanted to find a system that we could process their potential cases through the federal courts fairly. I wanted to be able to find the meritorious cases and get relief for those prisoners as quickly as possible and get rid of the frivolous cases as quickly as possible. And so I really worked hard to try to find a system to do that.
What impact do you think your work along those lines with Judge Aldister had, and how quickly did it have impact?
My work with Judge Aldister, he was, in 1975, he was chair of a committee on, I think actually it was in 1976, he was chair of a Federal Judicial Center committee on procedures for handling prisoner civil rights cases in the federal courts. And this was during the time when I had just started handling, and I was really struggling to find a good way to handle them. And I got their tentative report, his committee's tentative report, on how the federal courts could handle prisoner cases. Well, I took a look at that and saw I was doing a lot more different things than that report recommended. So I wrote a letter to Judge Aldister, which I recently found, telling him that I was interested in the work of his committee and that I had come up with a lot of procedures which went way beyond what he had recommended. And I wondered whether I was doing too much. I got a call from Judge Aldister, invited me to join his committee in their next meeting in Chicago. I went to Chicago. Next thing I knew, I was a member of the committee. And I prepared an outline for the members of the committee of what the things that I did to handle prisoner civil rights cases. There were several district judges. Judge Aldisert was the Court of Appeals judge, and there was a law professor on that committee. I was the only magistrate on the committee. And the committee refined my procedures, which became the recommended procedures for handling prisoner civil rights cases in the federal courts. Our manual was sent out to every judge in the country with a questionnaire. What else do you need to help you with these difficult cases? The answer came through loud and clear. The judges wanted more help with the substantive law. There were no treatises on the law of prisoners' rights at that time. This was an area that was just developing. It was just beginning. And the judges didn't want their law clerks spending their time researching the law of prisoners' rights. They wanted their law clerks working on the cases that were filed by attorneys. So when I started handling the prisoners' cases, I started keeping an outline. Every week I would update it. Decisions were coming down every week from the courts of appeals and the Supreme Court. And I would give that to the members of the Aldisert Committee, the Federal Judicial Center Committee. So finally, when they got the response from the judges throughout the country that they needed something on the substantive law of prisoners' rights, they looked to me and they said, Ila Jean, this is your outline. We want it published. Well, it took a year of working, 7 days a week. I remember during that year, on Sunday, I would leave the office at 5 o'clock. I was given 2 law students from Duquesne Law School. One was the editor of the Law Review, and the other was on the editorial board of the Law Review. And the thing that was difficult about this, we were preparing this 500-page book for publication, and yet constantly new decisions were coming down. So I had to keep going back and add cases to it. When it finally went to the printer, it was current. 2 weeks later, it was behind. So that was published in 1979. It, again, was sent out to every judge in the country. Before long, the judges said, we need it updated. So in 1981, I prepared a supplement that was sent out to every judge in the country. After that, I was getting involved in our district, handling all types of cases. Our jurisdiction was expanded, and I could no longer keep up with the cases that were coming down. And by that time, now there were treatises on the law of prisoners' rights which were being published. So the judges really didn't need my book anymore.
Were there any memorable cases that came before you around this time, or were they all fairly routine?
Let me see. Is there a particular case you're thinking of? Okay. There were so many cases. Right now, I can't think of any particular cases that really stick out. It was just handling volumes and volumes of cases as fairly as I could.
By the early 80s, could you see that this nature and the scope of the magistrate's position had changed from when you started? Did you see some progress in that way?
Yes. I guess what happened was, at one point, the caseload was going up so high, that Judge Mitchell and I got behind in handling the Social Security disability cases. We could, with our criminal duty and the Social Security cases, they were coming in like 50 a month. And we only had half of our time to even devote to them. Plus, he was doing habeas and I was doing prisoner rights. So finally, the judges decided to stop assigning Social Security cases to us for a while. Finally, we got a third magistrate, who was Magistrate Gary Lancaster, who is now a district judge. There were 3 of us. So finally, we found out that we were getting caught up. And I found out that one of the judges had decided we should go back to handling all the Social Security disability cases again. This really upset me. I wanted to be playing a more major role as a magistrate in federal court. I didn't want to spend all my time reviewing these long administrative records. They were important cases, but they took an incredible amount of time. So I remember I actually considered leaving. I thought, if this is what the judges want us to do, if they want us to spend all our time handling issuing warrants in cases and handling Social Security and habeas corpus and prisoner civil rights cases, I have to find something else to do. This does not offer enough challenge or interest to me. I was driving home one night, and all of a sudden an idea hit me. We could divide all the cases evenly among the magistrates and the judges. We would handle every type of case that is filed in the court. I wanted to call my colleagues, Judges Mitchell and Lancaster, when I got home, but I didn't want to bother them at home. So the next day I went to them and explained my idea. They were both very excited about it, and I worked out a proposal. Well, the judges weren't very excited about it. This would be a major expansion of our duties. On the other hand, they were overwhelmed. By that time, we had several vacancies on the court. They were not able to keep up with the volume of cases. And they thought, well, at least this will give us, we can turn over, I forget what the percentage was, maybe a third or a fourth of our cases, to the magistrates to manage. And that'll give us a break. So we'll try this for a year. So it was very exciting. After that, we got every type of case that was filed in the court to manage. When the year was up, there was no talk about going back to the old system. So we continued, and that was a major change in the magistrate's role in our court.
You had mentioned earlier that you had at least one meeting with Chief Justice Rehnquist about...
Is it time?
I was going to tell there's about 7 minutes left on the tape.
Okay. Would
Do
you
you
rather
want to change
stop
it?
it now and change tapes, or
It's up to you guys. I
Yeah.
don't know how long the answer is going to be or how long.
maybe you should change
Yeah, it would be
tapes.
nice. Then we can relax a
so-
little bit.
Just